Welcome everyone to Lesson 3.1, Identifying High-Risk AI Systems. This is a critical lesson within our module on high-risk AI systems, and it's where we really get into the practical application of the EU AI Act. Up until now, we've talked about the overall structure, the risk-based approach, and the prohibited practices. Now, we're going to focus on how to determine if an AI system you're developing, deploying, or using falls into that high-risk category, triggering a whole host of compliance obligations. Why is this so important? Because getting this wrong can have serious consequences. Misclassifying a high-risk system as low risk means you won't be implementing the necessary safeguards, potentially leading to significant harm, legal penalties, and reputational damage. So, a thorough understanding of the high-risk classification criteria is absolutely essential. The EU AI Act doesn't apply a blanket set of rules to all AI. It takes a risk-based approach, and the category of high risk is where the most stringent requirements come into play. These requirements, which we'll explore in detail in subsequent lessons, cover everything from data governance and technical documentation to transparency, human oversight, and cybersecurity. So, how do we identify these high-risk systems? The AI Act provides a two-pronged approach outlined in Article 6 and a detailed list of specific use cases in Annex 3. Let's start with the two-pronged test. Article 6, the first prong, deals with AI systems that are either part of or are themselves products already covered by existing EU harmonization legislation.
Think of things like machinery, toys, medical devices, and vehicles. These are areas where we already have robust product safety regulations. The AI Act layers on top of these. Specifically, an AI system is considered high risk under this first prong if two conditions are met. First, the AI system must be a safety component of a product, or the AI system itself is the product, and that product is covered by one of the pieces of Union harmonization legislation listed in Annex 1 of the AI Act.
Second, that product or the AI system itself must be required to undergo a third-party conformity assessment under that existing legislation. Let's break that down with an example. Imagine a robotic arm used in a manufacturing setting. That arm is covered by the Machinery Directive, which is listed in Annex 1. If an AI system is used to control the arm's movements, ensuring it operates safely around human workers, that AI system is a safety component. If the Machinery Directive requires a third-party conformity assessment for that robotic arm, then the AI system controlling its safety functions automatically becomes high risk under the AI Act. Another example, consider an AI-powered medical diagnostic tool. This tool is itself a product, and it falls under the Medical Devices Regulation, also listed in Annex 1. If that regulation requires third-party conformity assessment, the AI diagnostic tool is classified as high risk. The key takeaway here is the link to existing product safety laws.
If you're already dealing with products regulated under those laws and you're incorporating AI as a safety component, or the AI system is the product and a third-party assessment is required, then you're automatically in high-risk territory under the AI Act. Now let's move to the second prong of Article 6, and this is where Annex 3 comes into play. Annex 3 lists specific use cases of AI systems that are considered high risk regardless of whether they're part of a product covered by other EU legislation. These are standalone AI systems, or systems used in contexts where the potential for harm to health, safety, or fundamental rights is deemed significant. Annex 3 is quite extensive, so we'll go through each area carefully. It's divided into 8 broad categories: biometrics, critical infrastructure, education and vocational training, employment, essential services, law enforcement, migration, asylum and border control management, and administration of justice and democratic processes. Let's start with biometrics. This category includes remote biometric identification systems, which are systems that identify people at a distance without their active involvement by comparing their biometric data to a database. Think facial recognition technology used in public spaces. These are generally considered high risk, with very specific and limited exceptions for real-time use in law enforcement, which we covered under prohibited practices.
But it's crucial to note the exception. AI systems used solely for biometric verification, including authentication, where the purpose is simply to confirm that a person is who they claim to be, are not automatically classified as high risk. For example, using facial recognition to unlock your phone or to gain access to a secure building where you are presenting yourself for verification is not in itself considered high risk under this definition. The biometrics section also includes AI systems used for biometric categorization, meaning assigning people to specific categories based on their biometric data. If this categorization is based on sensitive attributes like race, political opinions, or sexual orientation, it's prohibited outright, as we discussed in Lesson 2.1. But even if it's not based on those prohibited categories, biometric categorization systems are generally considered high risk. Finally, under biometrics, we have emotion recognition systems. These are AI systems that try to infer people's emotions or intentions from their biometric data. Unless they fall under the prohibition in Article 5, these are considered high risk. Next, we have critical infrastructure. This category covers AI systems used as safety components in the management and operation of critical digital infrastructure, road traffic, and the supply of water, gas, heating, and electricity.
The failure of these systems could have widespread and serious consequences, hence the high-risk classification. For example, an AI system that manages the power grid, making decisions about energy distribution, would fall under this category. Moving on to education and vocational training. AI systems used to determine access to educational institutions, evaluate learning outcomes, assess the appropriate level of education for an individual, or monitor student behavior during tests are all considered high risk. The potential for these systems to perpetuate bias and discrimination or to unfairly limit opportunities is a key concern here.
In the area of employment, workers' management, and access to self-employment, AI systems used for recruitment, making decisions about promotions or terminations, allocating tasks, or monitoring worker performance are classified as high risk. Again, the potential for bias and discrimination and the impact on people's livelihoods are major factors. The next category is access to and enjoyment of essential private and public services and benefits. This includes AI systems used by public authorities to evaluate eligibility for public assistance benefits, like healthcare or Social Security. It also includes AI systems used to evaluate creditworthiness or credit scores, with the exception of those used for detecting financial fraud. And it covers AI systems used for risk assessment and pricing in life and health insurance. The common thread here is that these systems make decisions that can have a profound impact on people's access to essential resources and opportunities. Then we have law enforcement. This is a particularly sensitive area, and many uses of AI in law enforcement are either prohibited or strictly regulated. AI systems used for risk assessments of individuals, polygraphs, evaluating the reliability of evidence, and profiling, insofar as they are not prohibited, are considered high risk.
The potential for these systems to infringe on fundamental rights, like the presumption of innocence and the right to a fair trial, is a major concern. Similarly, in migration, asylum, and border control management, AI systems used as polygraphs for assessing risks posed by individuals entering a country or for assisting in the examination of asylum or visa applications are considered high risk insofar as their use is permitted. The vulnerability of people in these situations and the potential for discriminatory outcomes are key factors. Finally, we have the administration of justice and democratic processes. AI systems used to assist judicial authorities in researching and interpreting facts and law, or in applying the law to a concrete set of facts, are considered high risk. The integrity of the judicial process and the potential for bias in these systems are paramount concerns. However, it should be noted that AI systems used for purely ancillary administrative tasks that do not affect the administration of justice in individual cases, such as anonymization of judicial decisions, are not considered high risk. Also of note, AI systems used to influence the outcome of an election or referendum or voter behavior are classified as high risk, unless voters are not directly exposed to the output of the system.
Now it's important to remember that this list in Annex 3 is not static. The Commission has the power to amend it through delegated acts, which we'll discuss shortly. But before we get to that, I want to address a crucial exception to the high-risk classification for systems listed in Annex 3. Article 6 states that an AI system listed in Annex 3 is not considered high risk if it does not pose a significant risk of harm to health, safety, or fundamental rights. This is a critical point. The Act recognizes that not all AI systems used in these areas are inherently dangerous. The Act then provides 4 conditions, and if any of these conditions are met, the system may not be considered high risk unless it involves profiling. These conditions are: 1. The AI system is intended to perform a narrow procedural task.
2. The AI system is intended to improve the result of a previously completed human activity. 3. The AI system is intended to detect decision-making patterns or deviations from prior decision-making patterns and is not meant to replace or influence the human assessment without proper human review. And 4. The AI system is intended to perform a preparatory task to an assessment. Let's look at some examples to illustrate these conditions. A narrow procedural task might be an AI system that converts unstructured data into structured data or categorizes incoming documents. These are tasks that are limited in scope and don't inherently involve high-stakes decisions. An AI system that improves the result of a previously completed human activity might be a tool that helps refine the language used in a document, ensuring consistency in tone or style. The human has already done the core work. The AI is simply providing assistance.
An example of detecting decision-making patterns could be an AI system that flags potential anomalies in a teacher's grading based on their past grading patterns. The AI is not making the grading decisions. It's simply identifying potential inconsistencies for human review. And finally, a preparatory task might be an AI system that helps organize files or translate documents, providing support for a subsequent assessment. However, it's vital to remember the caveat. Even if one of these conditions is met, if the AI system involves profiling, it's always considered high risk. Profiling, as defined in the GDPR and other EU data protection laws, means any form of automated processing of personal data to evaluate certain personal aspects relating to a natural person. So, if you're a provider and you believe your AI system, which falls under Annex 3, meets one of these 4 conditions and doesn't involve profiling, you must document your assessment thoroughly before placing the system on the market or putting it into service. You'll need to be able to justify your conclusion to the national competent authorities if requested. And you're still obligated to register the system in the EU database.
The Commission is also tasked with providing guidelines to further clarify the practical implementation of these conditions, with specific examples. These guidelines will be an important resource for providers. Now, let's talk about the role of delegated acts in amending Annex 3. The AI Act recognizes that technology evolves rapidly, and the list of high-risk use cases may need to be updated. Article 7 gives the Commission the power to adopt delegated acts to add, modify, or remove use cases from Annex 3. This is a significant power, and it's subject to specific criteria and procedures. The Commission can add or modify use cases if the AI systems are intended to be used in one of the areas already listed in Annex 3, and if they pose a risk of harm to health and safety or an adverse impact on fundamental rights that is equivalent to or greater than the risk posed by existing high-risk systems. When assessing this risk, the Commission must consider a range of factors, including the intended purpose of the system, the extent of its use, the nature and amount of data processed, the degree of autonomy of the AI system, the potential extent of harm, the vulnerability of affected persons, and the existence of effective redress mechanisms under other Union law.
The Commission can also remove high-risk AI systems from Annex 3 if they no longer pose significant risks and if the deletion doesn't decrease the overall level of protection. These delegated acts are subject to parliamentary scrutiny, and the European Parliament and the Council have the power to object to them. This ensures a level of democratic oversight over the Commission's power to amend the list of high-risk AI systems. To summarize, identifying high-risk AI systems under the EU AI Act is a two-step process. First, you need to check if your AI system falls under the definition in Article 6 relating to products already covered by other EU legislation. If it does, and a third-party conformity assessment is required, it's automatically high risk. Second, you need to examine Annex 3 to see if your AI system falls under any of the listed use cases. If it does, it's generally considered high risk, unless you can demonstrate that it meets one of the 4 conditions for exception under Article 6, and it doesn't involve profiling.
This classification process is crucial because it determines the level of compliance obligations you'll face. And remember, the list in Annex 3 is not fixed. It can be amended by the Commission through delegated acts. In our next lesson, we'll delve into the specific requirements for high-risk AI systems, covering data governance, technical documentation, transparency, human oversight, and more. But for now, make sure you have a solid understanding of how to identify these systems, because that's the foundation for everything else that follows.